Chapter 6, Act of Congress of July 8, 1870. Section 278. Mere superficial glances at the few sections in the Act devoted to trademarks have misled many persons, lawyers as well as laymen, as to the import of the language used in this scheme of protection to this species of incorporeal property. One erudite gentleman flung down the apparently simple sentences, with the exclamation, "He that runs may read," meaning that a sweep of the eye sufficed for a full comprehension of the subject. This faith in his own correctness, however, was much shaken, when the inaccuracy of even his scripture quotation was turned against him as an illustration of carelessness, and he found that instead of being cursorily disposed of in a few enigmatical sentences, the law should be so plainly exhibited that he may run that readeth it, and circulate its lessons. The most common language has been misunderstood, if not misread, and its spirit and reason utterly misconceived. The necessity of interpreting each line, and nearly every word, has been demonstrated to the writer in his official capacity, so that the following exegetical commentary is little more nor less than the harmonious crystallization of innumerable decisions. Let us invoke the principles of legal interpretation and construction, in order to clearly ascertain the intention of the legislature in this Act of July 8, 1870. Section 279. There are certain conditions precedent to registration, the non-fulfillment of any of which may prove a source of trouble to the proprietor of the trademark, and possibly avoid his right to protection. Section 280. As many of the authorities cited in this treatise are decisions from the judicial tribunals of France, it will not be unprofitable to glance at the French Act, the basis of those decisions, where we will discern a strong resemblance to this. Section 281. The first article makes trademarks optional, and gives the comprehensive definition of the term marques de fabrique de commerce, which our tongue shortens into the compound word trademark. The second article prescribes that no one can maintain a suit to establish in himself the exclusive title to a trademark, unless he shall have deposited 2 copies of his symbol with the clerk of the Tribunal of Commerce of his domicile. The third article fixes the term of protection under that law for 15 years, and provides for a renewal of deposit, equivalent to our registration, for a new term of 15 years. By Article 5, all foreigners who possess in France establishments of industry, or of commerce, shall enjoy for their products the benefit of that law, upon the fulfillment by them of the conditions thereof. By Article 6, foreigners and Frenchmen whose establishments of business are outside of France shall equally enjoy the benefit of the said law for the products of their establishments, if in the countries where they are situated diplomatic conventions shall have granted reciprocity for French marks. In this case, the place of deposit of foreign marks shall be with the clerk of the Tribunal of Commerce of the Seine. There are penal provisions which, being entirely local in character, cannot interest the general reader. It will be seen that there are striking points of resemblance between the French law and our own. Section 282. The congressional provisions in relation to the subject of trademarks commence with Section 77 of the Act aforementioned. We will take it up piecemeal, and endeavor to dispel the mists that obscure some portions of it, and which have innumerable times compelled this same pen to make expositions in an official way. The first paragraph runs thus, Section 77. And be it further enacted, that any person or firm domiciled in the United States, and any corporation created by the authority of the United States, or of any state or territory thereof, and any person, firm, or corporation resident of or located in any foreign country which by treaty or convention affords similar privileges to citizens of the United States, and who are entitled to the exclusive use of any lawful trademark, or who intend to adopt and use any trademark for exclusive use within the United States, may obtain protection for such lawful trademark by complying with the following requirements, to wit. Section 283. Any person. Do these words literally mean that any man, woman, or child, any citizen or alien, any resident, or non-resident, may obtain the protection of this law? Do they in effect include any person in the broadest sense of those words? This position has been strenuously insisted on before the Patent Office, by solicitors who had not the time nor the desire to think for their clients. We know that in law persons are divided into natural and artificial persons. Men, women, and children are called natural persons, and a corporation is an artificial person. But in another sense, by person is meant the part which a man plays in society. In law, man and person are not exactly synonymous terms. Any human being is a man, whether a member of society or not. A slave, though a man, is in general considered not as a man, but as a thing, a chattel. Lear gives the derivation of the word person. He says that, in its primitive and natural sense, it signifies the mask with which actors who played dramatic pieces in Rome and Greece covered their heads. In the vast amphitheatres it was impossible for a man to make himself heard by all the spectators. Recourse was had to art. The head of each actor was enveloped with a mask, the figure of which represented the part he was to play, and it was so contrived that the opening for the emission of his voice made the sounds clearer and more resounding. Vox personabat, whence the name persona was given to the instrument or mask which facilitated the resounding of his voice. The name persona was afterwards applied to the part itself. It is in this latter sense of personage, or of the part which an individual plays, that the word persona is employed in jurisprudence, in opposition to the word man, homo. When we speak of a person, we only consider the state of the man, the part he plays in society, abstractedly, without considering the individual. Now, if the law-making body in this case had intended the words any person to be taken literally, without qualification or restriction, there would have been no need of mentioning any corporation, a corporation being a person as much as is a human being. Nor could it have meant every human being, independent of his state and position, for such a broad construction would include a traitor in arms against the government, an outlaw, an alien enemy, one deemed to be civilly dead by reason of monastic vows, or judicial condemnation, or one under interdiction, as one non compos mentis by the sentence of a competent tribunal, or a clergyman of the established Church of England, who is inhibited from secular pursuits in which a trademark could be available. We must consider the object of this statute. It is to secure protection upon the fulfillment of certain conditions precedent. Protection can be awarded only through the instrumentality of judicial proceedings. No one may obtain protection who cannot place himself in a position to be protected. To grant, and to take, are correlative terms. The phraseology is elliptical. By person is meant all men not under legal incapacity, or, as the paragraph explains itself, to apply to such as are entitled to the exclusive use. To have no title, and not to be in a condition to assert it, have the same result. How could the alleged mark be lawful, with no law to uphold it? One condition precedent to registration and consequent protection is the filing of a declaration under the oath of the person, and c. By person is meant one who can legally take an oath. A perjured felon's oath cannot be accepted. Therefore, a perjured felon cannot be included by the general expression any person, which consequently does not mean any and every man regardless to his position and character. The conclusion is obvious. The words any person include only such as are capable of taking and holding title. Section 284. If we needed any further confirmation of the correctness of this interpretation of the word any as used in this section of the statute, we might deduce a parallel case furnished by this very same general act. Section 24 says, that any person who has invented or discovered any new and useful art, machine, and c. may upon payment of the duty required by law, and other due proceedings had, obtain a patent therefor. Does the word any mean literally any and every person, as is contended by the superficial reader? No. Why does it not embrace every person who shall have fulfilled all the conditions and requirements of the section? Because the general rule has an exception, as is obvious at a glance at section 16 of the statute. That says, that all officers and employees of the Patent Office shall be incapable, during the period for which they shall hold their appointments, to acquire or take, directly or indirectly, except by inheritance or bequest, any right or interest in any patent issued by said office. Just as one class of persons is expressly accepted by the words of the statute in one case, so is another class accepted by a necessary implication of law in the other case. Fragments of laws are not law. Any person having a right to the exclusive use of a trademark may obtain protection. If the right exist, it will be recognized. Section 285. Married women. By the common law of England and of this country, a married woman is wholly incapable of entering into mercantile contracts on her own account. By the fact of marriage, all the personal property which she has in actual possession becomes absolutely her husband's, as entirely as if she had made a transfer of it to him. But in several of our states, the common law, which was of feudal origin, being considered inappropriate to our own state of society, has been essentially modified by statutory provisions, and married women become sole traders, with or without the consent of their husbands. There is a growing disposition both in the legislatures and in the courts to hold that a woman who is deserted by her husband, and who is laboring successfully as a trader to maintain herself, and perhaps her children, is in substance a sole trader, liable on her own contracts, and entitled to her own earnings. If she may lawfully traffic in merchandise, it is because she has a property therein as a trader, and as an incident to her mercantile rights she is entitled to protection of her trademark. The office will not inquire into the question of marriage, nor will it question the age of any applicant. All other matters being regular, the certificate of registration will issue, leaving the subject of domestic relations to be settled in another tribunal. Section 286. Firm. A firm is the name, title, or style under which a company transacts business, hence, a partnership or house, as the firm of Help and Company. Seemingly there is an impropriety of language in using this word in connection with the word domiciled, for the idea of domicile involves that of personality. A mere name, title, or style, could not be domiciled. However, we have the consoling reflection that a want of grammatical correctness will not vitiate, if the meaning can be gathered, nam mala grammatica non vitiat chartam. The term may be used in a corrupted sense to mean the aggregation of individuals represented by a certain title, i.e., that the individuals comprising the house must be domiciled. If used elliptically, then it seems all the partners of the house must be meant. In that case, suppose that some of the partners are domiciled in one country and some in another. Could the house be said to be domiciled in this country? A want of due care in this regard may possibly give rise to perplexing and complicated questions. Before applying for registration, it should be clearly ascertained whether a number of applicants constitute a partnership or not. If yea, the safer course would be for the domiciled members only to apply, for if the title to the mark be vested in individual names, the partnership may by license have all the benefit of it. This apparently trifling point is worthy of consideration in order to guard the interests of owners claiming protection under this statute, even in cases where at common law the mark would be valid whether the owners were domiciled or not. Section 287. Domiciled. In certain cases domicile is an essential prerequisite to registration, and, being essential, it should be set out in the application papers. When not averred distinctly, it will be inferred from circumstances. It is because the term domicile has not been understood, and has so often been confounded with a mere abiding place, that the office has been led to demand an oath, showing of what country the applicant is a citizen, the same as in applications for patents. The office will then assume that a certain place or country is the party's domicile. What is the meaning of the word domicile? The definition of the term is not without difficulty, for although so many powerful minds have been applied to this question, there is no universally agreed definition of the word, nor an agreed enumeration of the ingredients which constitute domicile. Two things must concur to constitute it: first, residence, and, secondly, the intention of making a place the home of a person. There must be the fact and the intent. However, in many cases, actual residence is not indispensable to retain a domicile, but it is retained animo solo by the mere intention not to change it, or adopt another. Thus, if a person should go on a voyage to sea, or to a foreign country, for health, or for pleasure, or for business of a temporary nature, with an intention to return, such a transitory residence would not constitute a new domicile, nor amount to an abandonment of the old one. For it is not the mere fact of inhabitancy in a place which makes it the domicile, but it is the fact, coupled with the intention of remaining there, animo manendi. Section 288. There is sometimes no small difficulty in deciding upon the place of domicile, in a strict and legal sense. Residence is oftentimes of a very equivocal nature, and an intention to return to a former residence is still more obscure. Both are sometimes to be gathered from slight circumstances of mere presumption, and from equivocal and conflicting acts. Thus, at the federal seat of government there are many office holders in the civil service who claim domicile in states from which they have been absent many years, and in which they hold but the shadow of a nominal residence, and yet they assert and frequently exercise the right to vote in their respective states, just as our ministers to foreign courts, and soldiers and sailors may do, when they return to homes from which they have long been absent. To complicate the question as to their fixed, true, and permanent residence, these officeholders sometimes vote at the municipal elections in the District of Columbia, and their right to do so has been maintained by high legal authority. Yet an inhabitant of one state does not acquire a domicile in another by merely coming to the latter to seek employment, with the intention of residing there only if he should find it. In Abington v. North Bridgewater, the learned Chief Justice Shaw said truly that everyone has a domicile of origin, which he retains until he acquires another, and the one thus acquired is in like manner retained. The supposition that a man can have two domiciles would lead to the absurdest consequences. If he had two domiciles within the limits of distant sovereign states, in case of war, what would be an act of imperative duty to one would make him a traitor to the other. He might thus, during a period of hostilities, become an enemy to himself, or be bound to do personal service in two military districts of the same state at the same time, or in two countries be compellable to serve on juries at the same moment, or, as in our late Civil War, be held to duty as a conscript in one district when the quota of troops had actually been filled by him in another. Section 289. Every person must have a domicile somewhere. First, the place of birth of a person is considered to be his domicile, if at the time of his birth it was the domicile of his parents. If his parents are then on a visit, or on a journey, in itinere, the home of his parents, at least, if it be in the same country, will be deemed the domicile of birth or nativity. Persons born out of the limits and jurisdiction of the United States, whose fathers were at the time of their birth citizens of the United States, are citizens of the United States. But the rights of citizenship shall not descend to persons whose fathers never resided in the United States, for their domicile would be abroad. An illegitimate child follows the condition of his mother. A child born on the high seas has his domicile in the country of his parents. The domicile of birth of minors continues until a new one is obtained. Minors are generally deemed incapable, proprio mati, of changing domicile, and retain the domicile of their parents, and if the father die, his last domicile is that of the minor children. A married woman follows the domicile of her husband, but sometimes she may obtain one different from his, and institute proceedings for divorce. A widow retains the domicile of her deceased husband until she obtain another domicile. Prima facie, the place where a person lives is taken to be his domicile until other facts establish the contrary. When one removes to another place, with an intention to make it his permanent residence, it instantaneously becomes his place of domicile, and that although he may entertain a floating intention to return at some future period to his old home. It has so been considered in relation to the Chinese immigrants in the states of the Pacific, who nearly all hope to return to China during life, or to have their remains removed thither after death. The place of residence of a man's family is generally to be deemed his domicile, unless it be only a place of temporary establishment for his family. Residence, to produce a change of domicile, must be voluntary. If, therefore, it be by constraint, or banishment, arrest, imprisonment, the antecedent domicile remains, as in the case of the many thousand French soldiers who retreated into Switzerland, during the late war between their nation and North Germany, and also that of Don Carlos, who more recently retreated with some of his soldiers into France from Spain. The removal was not a matter of choice. Still, probably, any of those persons could obtain a domicile by intending to always remain in the land of exile. Section 290. There is a forensic domicile, forum domicilii, or place where one can sue and be sued. It may happen, and it often does, that the political, civil, and the forensic domicile are the same. But this is a matter not so much of general principle as of positive legislation in different countries. A person who resides in a foreign country, for purposes of trade, is deemed an inhabitant of that country by foreign nations, and his character changes with that of his country. In peace he is deemed a neutral, in war an enemy, and his property is dealt with accordingly in prize courts. It is doubtless in this sense that the word domiciled is used in the Act of July 8, 1870, as will be apparent upon a careful reading, for it was passed in the interest of commerce generally, and not with reference to the citizenship of applicants. The main point is this: does the claimant, by engaging in manufacturing and commercial pursuits in our country, add to its prosperity and wealth? If so, this statute shall give him additional protection and privileges. The policy of the law is to enhance our national prosperity. He whose actions have not that tendency cannot reasonably claim an advantage over anyone else. As an example of the practical working of this theory, we will take a case recently submitted for advice. A native of the state of Rhode Island, a natural-born citizen of the United States, and still such citizen, continued to reside in this country for many years after attaining his majority. For about 18 years he has been established in China, as a tea merchant, and exports largely to this country. He desired to register his trademark for teas, but entertained doubts of the feasibility of his wish, on the ground of want of domicile. He was informed through his counsel that so far as this statute is concerned, he must be regarded as a Chinese subject, and as such foreign country does not by treaty afford similar privileges to citizens of the United States. He could not avail himself of the provisions of this act. His able counsel fully acquiesced in this view, and so the matter ended. Section 291. Citizenship is not an element to entitle or debar from registration under this statute. The question of fealty or allegiance does not arise. The citizen of the United States, resident and in commerce in a foreign country, and if not in commerce why have a trademark, is adding to the wealth and prosperity of that foreign country. He has the throne in his lot. Commercially, he is a citizen of that country. To be sure, he can resume his prior status. If he do not choose so to do, let him use his influence to secure to all of his fellow citizens of the United States the privileges he now seeks here. One may for half a century have been a trader in the city of New York, and not be included within the meaning of this act, or he may not have yet been in the United States for more than an hour, and be included. What was his intention, as to permanency? Section 292. Let us consider a hypothetical case, to illustrate the idea of the necessity of a strict compliance with the statute, and the rules of practice. The late Mr. Nicholas Bodisco, who died in 1872, while connected with the Russian legation at the Brazilian court, was born in Georgetown, D.C., in 1844, his mother being a natural-born citizen of the United States. Suppose that the gentleman had embarked in mercantile business in the city of Washington, and had applied for the registration of a trademark. Would it have been sufficient for him to merely allege his residence in Georgetown, and his place of business in Washington? No, he should also have averred his place of domicile, for such is a material fact, and therefore should always be alleged. Why? Because our government, and the public at large, have a right to know the exact status of everyone to whom protection is conditionally promised by this legislative enactment. If he had then alleged his domicile, the fact would have transpired that his domicile was in Russia. Why so? Because, at the time of his birth, his father was envoy extraordinary, and c. of the Emperor of Russia, and in legal contemplation his domicile was that of his father, and not having renounced his allegiance to his own country, but actually continued in the diplomatic service, he had not acquired a domicile here. But what matter would that have been, since the residents of all foreign countries affording privileges of protection to trademarks to our people are provided for in this act? Not at all. The object of registration is protection in our courts, and the right to that protection might at any time be suspended by the supervention of a state of war between the countries. He would take the certificate, if at all, under an existing treaty, and subject to all legal conditions and contingencies. Section 293. One effect of the law of national domicile may be this: it may affect the validity of the transfer of a trademark by assignment, as provided for in Section 81. If by the law of the place where a person has his domicile he is of legal age at the age of 20, and has the faculty of disposing of his property there situate, the same faculty will extend to his property situate in another country, where he would not be capable of alienating until he had reached the age of 25 years. For example, the modern Civil Code of France expressly declares that the laws concerning the condition and capacity of persons govern Frenchmen, even if residing in a foreign country. Thus French minors, incapable of binding themselves by engagements of commerce, unless they are emancipated or authorized, cannot bind themselves in commercial transactions in a foreign country, even when the law of that country does not require the like conditions. So does the personal incapacity of French married women follow them everywhere, so far as the French tribunals are concerned. Any man obtaining an assignment of a trademark would prefer to be assured that he might assert his title the world over. Section 294. Whether a member of an Indian tribe resident within the territory of his nation, and subject to its laws, would be regarded as included within the provisions of this Statute of 1870, is a question that may arise, but has not been officially passed upon. The language of Subdivision 3, Section 8, Article 1, of the Constitution, seems to imply that a treaty would be necessary for the regulation of commerce with such tribes, and this law relates to commerce. Section 295. The national character which a man gains by residence may be thrown off at pleasure, by a return to his native country, or even by turning his back on the country in which he had resided, on his way to another. It is an adventitious character gained by residence, and which ceases by mere residence. It is manifest that the fact of mere citizenship is not conclusive on the question of domicile. An Englishman came to this country, and became naturalized, and 2 years afterward returned to England, where he continued to reside for 16 years, with the exception of a few months spent in visiting this country. Held, that he must be regarded as having again become a British subject. The same doctrine was held in the Supreme Court of the United States in 1814, where a naturalized citizen, in time of peace, returned to his native country for the purpose of trade, but with the intention of returning to his adopted country. He remained in his native country for a year after the commencement of the war between the two countries, but only for the purpose of winding up his business. Held, that he had gained a domicile in his native country. In still another case, a residence of 13 years in an enemy's country was held sufficient to invest the party with the character of an enemy. In the Civil War in the United States, property was condemned on the ground of domicile only. It was decided, first, that if a place was in the firm possession and under the control of the rebel enemies, it was, for the time, and in the technical sense of the prize law, enemy's territory. Second, that the property of a person domiciled in that place at the time of capture was liable to condemnation as enemy's property, in the sense of the prize courts. And lastly, that although the owner was a citizen of the United States, and had always resided in that place, which was held to be of right a part of the United States, and of right a proper place of residence to constitute citizenship of the United States, yet the property of such a person was to be condemned without inquiring whether he was or was not, in his intentions or acts, loyal or disloyal. The same rule was applied to the property of foreigners domiciled in such places. Section 296. As this law is in the interest of commerce, it may safely be assumed that the word domiciled will receive a favorable rather than a restricted stringent interpretation. It is a remedial and beneficial statute, and the words of such a statute are to be construed largely and beneficially, so as to suppress the mischief and advance the remedy. Especially should this be the case in view of the fact that in the United States, as in England, and a few other countries, the courts are as open to the non-resident alien friend as to the resident citizen, that is, so far as regards common law rights and remedies. It is only when one seeks to avail himself of the provisions of this particular statute that he is held to set forth domicile, and even then, it is probable that the courts would not require proof of anything more than forensic domicile. Yet, at all events, the subject is worthy of attentive consideration. Section 297. Any corporation, What do these words mean? Do they embrace literally any and every corporation, sole and aggregate, ecclesiastical, municipal, manufacturing, and commercial? Corporations formed for scientific, educational, and a score of other purposes. Counsel have asserted that all kinds of corporations, however unconnected with commerce, are included. If not in trade, why have a trademark? If a non-trading corporation cannot have a trademark at common law, how can it possibly have one by virtue of this Act of Congress? This statute does not create trademarks, for no power to do so exists under the Constitution, and it would be an absurdity to attempt to create a symbol of commerce, which, being the emblem of its owner, each man must adopt for himself. The right to use a certain mark for goods does not depend upon statutory enactments, but has its foundation in the immutable law of nature. Congress had only authority to regulate commerce, and it did not attempt to transcend its powers. It could not change the natures of things. We are referred to the common law for the rules which govern those natures, and it has repeatedly been declared that statutes which alter common law remedies, or effect common law rights, must be strictly complied with. Witness the maxim, nihil quod est contra rationem est licitum, for reason is the life of the law. And such statutes are to be construed sensibly, and with a view to the object aimed at by the legislature. An ancient and settled system ought not to be overturned, except by clear, unambiguous, and peremptory language. Section 298. This statute does not make valid any act on the part of a corporation which would not be valid without it, and does not in the slightest degree add breadth to the provisions of its charter. Therefore, it is a corollary that an ecclesiastical, educational, eleemosynary, or other non-mercantile corporation, is not contemplated by this Act. In one case, the applicant set forth that it was engaged in the manufacture and distribution of pamphlets, circulars, and other publications, and that the proposed trademark was to be printed thereon, and upon the notices which advertise the same and the business of the company to the public. It did not appear, nor could it be inferred, that the articles upon which the mark was intended to be applied were to be sold. Therefore they were not merchandise within the meaning of the statute. The application was rejected. In another case, where a picture of a safe and a watchdog was filed for registration by an insurance company, it met a similar fate. This picture was not intended to be sold as a work of art, for then it might have come under the copyright law, and been entered in the office of the Librarian of Congress. Nor was it to be affixed to merchandise to be sold. For an insurance company does not traffic, but it was to be printed upon policies, renewals, billheads, and by way of ornament. The purpose of registering a mark under such circumstances is inconceivable. What beneficial end could it possibly serve? It could not be turned into a technical trademark until it should actually be affixed to merchandise, and this artificial person, a company formed to insure against loss by fire, had no power in law to affix it to merchandise. The sole object of registering a trademark is to obtain protection against infringement by a rival trader, and that protection could only be obtained through judicial process. How could such a corporation come into court as a trader? In this case, the special examiner having charge of the subject declined to receive it, for want of jurisdiction, and the fee was returned to the applicant. Section 299. If the office had permitted registration in such cases, what absurd consequences might have flowed therefrom? Other corporations of a similar or analogous nature would perhaps have demanded the certificate which to them might have seemed like the wand of an enchanter. A corporation sole is recognized as existing in the United States. Such is a minister of a parish seized of a freehold, as persona ecclesiae, the same as in England, and the right once established cannot be divested even by an act of the state legislature. In Massachusetts, a minister seized of parsonage lands, is a sole corporation for that purpose. Such a corporation sole cannot alienate, but has survivorship. Now, if any and every corporation is intended to be embraced by this statute, why not let in such a minister of a parish, not in his individual capacity as John Stiles, but as rector? The proposition is too devoid of sense to warrant another word, and would be dropped but for one fact: an appeal has been taken in just such a case, and is still pending. Section 300. Common sense and good faith are the leading stars of all genuine interpretation. We do not take language literally, but look at the reason which underlies it. The command, "Thou shalt not kill," does not prohibit killing in a just war, or in defense of one's person. When the minister in the pulpit tells us to sing 3 verses of a certain hymn, we do not take him literally, for his words do not mean exactly what they say. A hymn is in poetical form, and in poetry each line is a verse. Therefore we at once perceived that the careless speaker means that we shall sing 3 stanzas, as otherwise the sense would be incomplete and be turned into sheer nonsense. Dr. Lieber has given an illustration of the necessity of consulting the rules of reason in applying language. He takes the word horse, which means many different things. In Webster's dictionary we find that it may mean 1. A hoofed quadruped of the genus Equus, 2. The male of the genus, 3. Mounted soldiery, 4. A frame with legs for supporting something, 5. A mass of earthy matter in mining, 6. In nautical affairs, a foot rope extending from the middle of a yard to its extremity, also a rope for hoisting a yard, or extending a sail on it. We always should take a word with its peculiar signification in the art, science, sect, and see, according to what is termed usius loquendi. When Congress used the word corporation, in the same paragraph it was also said who are entitled to the exclusive use of any lawful trademark, and c. The corporation must show that the law of its creation gave it authority to make such contracts as it seeks to enforce, and the act of registration under this statute is a contract between the United States on the one side, and the proprietor of the trademark on the other, whereby protection is promised upon certain conditions precedent and subsequent. Section 301. Treaty, or convention. This phraseology was conceived in a liberal spirit, looking to the encouragement of reciprocity. The office has given to these words a very liberal construction, and, in all cases when the full scope and intent of a treaty of commerce is somewhat dubious, it presumes in favor of the applicant. Thus where a British subject, resident in his own country, applied for registration, it was held that the English Act of Parliament, entitled the Merchandise Marks Act of 1862, was equivalent to a convention. Indeed, the right of an alien friend to protection in the English courts did not depend upon the passage of that statute, for in many instances previous thereto, the said courts had recognized and enforced the doctrine. In Pisner v. Lawson, it was shown that at law as well as in equity, an alien friend, not at any time a resident in England, might maintain a personal action for an injury done within the realm. It was held by Woodbury, J., in the United States Circuit Court for the District of Massachusetts, in 1846, that British subjects had the same privileges in our judicial tribunals as our own citizens. The third article of our Treaty of 1794, with England, gives the people of both powers the authority freely to carry on trade and commerce with each other. So, said the learned judge, we are under treaty obligations to Great Britain and most other European powers, to admit their merchandise on favorable terms, and to allow their merchants to trade here as those of favored nations. But it would be a mockery of such provisions and engagements, if we prevented them from selling their goods after arriving here. Ch. J. Marshall, in Brown v. State of Maryland, 12 Wheat. 447, unless noxious to health or morals, or if we made onerous discriminations against them, or prevented their receiving the proceeds of their goods, or abstained from yielding protection against injuries to them, or to their marks. This doctrine had previously been asserted by Story, J., in the same court. Mr. Justice Woodbury, in the case above cited, said that an alien is not now regarded as the outside barbarian he is considered in China, and the struggle in all commercial countries for some centuries has been to enlarge his privileges and powers as to all matters of property and trade. So, too, heavy taxation of alien merchants was guarded against in Magna Carta, allowing them to go and come, and buy and sell, without any evil tolls. It is hence, undoubtedly, that Montesquieu observed, that the English have made the protection of foreign merchants an article of their national liberty, and Thompson on Charters, p. 232, says, that once they enjoyed it even in war, in common with the clergy and husbandmen, in order that those who prayed, ploughed, and trafficked, might be at peace. Lord C.H. J. Hale said, so long ago as his time, that the law of England rather contracts than extends the disability of aliens, because the shutting out of aliens tends to the loss of people, who, when laboriously employed, are the true riches of any country. Therefore, when we consider the spirit and reason of this law, which are the promotion of reciprocity, it would be manifestly illiberal, if not positively unjust, to refuse registration of the mark of a resident of England. We need not hesitate, because the subjects of marks of commerce are not mentioned eo nomine in any treaty with England, nor in any convention, but, upon the principle of international comity, the presumption should be in favor of the residents of that country. It should be observed that the word citizen or subject of a foreign country is not used. The language is, any person, firm, or corporation resident of or located in. A citizen of the United States resident in such foreign country would, therefore, for the purposes of this Act, be deemed a foreigner. Section 302. Among commercial nations, there is a growing tendency to universal recognition of the emblems of commerce, known as trademarks, for such recognition operates as a safeguard against fraud on their own communities. Hence the many treaties and conventions upon this subject, and the liberal views entertained by the judicial courts of nearly all of the enlightened countries. By the term convention we mean all kinds of contracts less formal than a treaty, and all pacts, understandings, or agreements, the leading idea being the interchange of amicable relations and dealings. All nations are not alike liberal in respect to this matter, and require something more than a tacit understanding. Although a Frenchman in England had his rights as carefully protected in the courts of that country as if he were a British subject, independently of any treaty or compact, the French nation did not display a similar spirit of justice to Englishmen. Rowland and Son, of England, sued in France for an infringement of their trademark. The court refused them redress because they were undomiciled foreigners. The cases of Stubbs and of Spencer were decided against Englishmen on the same ground. The same ruling seems to have been uniformly made in the cases of all other foreigners under the same circumstances. In March, 1856, the Tribunal of Commerce of the Seine, in an infringement case, held, that, inasmuch as the complainant, Jean-Marie Fourriner, of Cologne water fame, was a foreigner, not admitted to establish his domicile in France, conformably to Art. 13 of the Code Napoleon, and as he had not proved that the civil rights he demanded were accorded by his nation to Frenchmen, his case must be dismissed. This course was taken, although the court admitted that his proprietary mark for his flasks of eau de Cologne had been recognized by numerous judgments and injunctions, and the defendant intended to continue the piratical use of it and the name of the complainant. Our countrymen met with a reception quite as unfavorable. In the court of Paris, in 1867, the complainant, Kemp, an American, proprietor of Florida water, eau de la Floride, sold as Agua Florida, had obtained in the court below a judgment for infringement of his trademark. It was held by the appellate court that, by Arts. 11 and 13 of the Code Napoleon, the foreigner not permitted by authorization of the emperor to establish his domicile in France could enjoy only those rights accorded to Frenchmen by treaty with the nation to which such foreigner belongs. Section 303, entitled to the exclusive use of any lawful trademark. The applicant must set forth his title, whether by original adoption, by assignment, inheritance, survivorship, or by operation of law, as when one has acquired a right to carry on the business of a bankrupt. From the facts alleged, will be deduced a conclusion as to the legality of the title claimed. The right to the use of the mark must be exclusive of all other persons. A trademark is an emblem of a man just as much as his written signature, and is used to denote that an article of merchandise has been made by a certain person, or that it has been sold, or offered for sale by him. If the same mark were to be used by different persons, for the same species of goods, it would lead to inextricable confusion, and its true and only legitimate purpose would be overturned, for then it would lack the essential element of an indication of origin or ownership. Section 304. The term corporation has been taken by some applicants for registration to mean any voluntary association or aggregation of individuals, although they do not possess the general characteristics of a corporation. Thus, in one case, the claimants set forth that they were engaged in business under the name of the Sorrento Wood Carving Company, and asked that a certificate should be issued to and in the name of such company. Held, the company has no legal existence by that name, not being incorporated, and is in reality a firm. The grant should properly be made in the individual names of the applicants, to avoid all question of legality. Section 305, Corollary. The meaning of the words any corporation is this: any company organized for the purpose of manufacturing and vending articles of merchandise, or organized for trading purposes, and duly incorporated by the authority of the United States, or of any state or territory thereof, and also any incorporated company, located in any foreign country which affords protection to the trademark property of citizens of the United States. In the latter case, without reciprocity, it could not be deemed to be a lawful trademark. The words, exclusive use within the United States, are not intended to restrict such to this country, but as the statute cannot have any extraterritorial force, it asserts protection only within the jurisdiction of our own tribunals. Protection beyond the limits of our own country is, of course, dependent upon treaty, convention, or national comity. Section 306. Protection. Persons have sometimes uttered strange ideas as to the meaning of this word, as here used. They have seemed to think that the seal of the Patent Office possesses a magical potency to blast any attempt at piracy, without the need of effort on the part of the owner of the mark. What does this term protection mean? It means that the power of the government, in its judicial branch, will be directed against infringers of lawful marks of commerce. At common law, protection was given in cases of encroachment upon an established trademark. A difficulty frequently presented itself, as to the evidence of adoption of the mark claimed. That difficulty may be stated in the language of the learned jurist, the late Mr. Justice Jura. The right does not become established until the trademark be so often used, and so long employed, exclusively and uninterruptedly, as to create the presumption that everybody would know and acknowledge that it was the distinctive badge of the plaintiff's ownership, and that the use of it by anyone must have been intended to deceive purchasers. Registration enables a suitor to dispense with proof of long user, and the production of the certificate of registration creates prima facie evidence of the plaintiff's title, eo instanti, and it operates as a notice, actual or constructive, to warn all other persons of the claim to exclusive ownership. Some judges have spoken of the act of registration as evincive of good faith, inasmuch as it fixes the date of adoption, describes the peculiar symbol, and tells to what particular class of merchandise the symbol is attached. The idea of a right to protection was no doubt founded on the notion that a reputation in the market for goods so marked could not be acquired until the sign which constituted the mark had been long used, and had acquired a currency like the guinea's stamp. Protection will also be given under this statute when both parties reside in the same judicial district, which was not the case before. It must be observed that protection is promised conditionally, upon compliance with certain requirements. Therefore, if any of the things required to be done have been omitted, the plaintiff must fail. In a suit founded upon a certificate of registration, the defendant, unless heedless to the superlative degree, will procure from the Patent Office an exemplification of the whole record of the plaintiff's application, and use its weak points as a weapon of defense. It may appear upon the face of the petition, specification, or the oath, that the office had never obtained jurisdiction, by reason of insufficient averments. Again, it may appear that such jurisdiction had never obtained, because the applicant had not presented a lawful trademark for registration. It would be folly to expect protection in such a case. The grant of letters of registration is in the nature of a contract between the public and the grantee, and a contract is a deliberate engagement between competent parties, upon a legal consideration. Such letters are as vulnerable as are defective patents. They bear but the merest semblance of a right, hardly serving the purpose of scarecrows. Unless the statute shall have been complied with in all its essential requirements, the certificate of registration shall prove as worthless as fairy money that crumbles into withered leaves, and be as false to hopes as the apples of Sodom, golden to the eye, turning to ashes in the mouth. Section 307. The word may in this section should read shall, this being a statute which directs the doing of a thing for the sake of justice or the public good. and to impose a positive and absolute duty. The party, therefore, shall receive protection, provided he shall have fulfilled all the conditions on his part. Requirements. Antecedent to Registry. Section 308. First, by causing to be recorded in the Patent Office the names of the parties and their residences and place of business, who desire the protection of the trademark names. The same practice obtains in cases under this section, as in patent matters, as to the names of applicants. Upon some portion of the application papers, the full names should appear, with as much particularity as in a conveyance of lands. The mere initials may do for an autograph. J. Styles may mean James, Jedediah, Joseph, or John Styles, and thus raise a question of identity. The full names of all the members of a firm should appear. In case of a corporation, the full and exact title should be given. The names of the witnesses should also appear in full in strict practice. Section 309. Residences and place of business. By the term residence is obviously meant the fixed, permanent place of abode. A man sometimes has more than one place of residence, as his city residence and his country residence. If a citizen, where does he vote? If domiciled in some foreign country, where is his temporary residence? We have seen, under the head of domicile, that the latter term signifies something more than mere residence. A man may come to this country with the intention of engaging in business for a certain time, but with the resolve to return to his native country when he shall have effected certain results. His domicile may be in England, his residence in New Haven, in the state of Connecticut, and his place of business in the city of New York. All these three things should appear upon the record. Section 310. Second, the class of merchandise and the particular description of goods comprised in such class, by which the trademark has been or is intended to be appropriated. Class of merchandise. Much carelessness is manifested in the use of generic for specific terms. A general description of one's whole stock in trade is too loose and indefinite, for example, groceries, hardware, perfumeries, medicines, oils, and c. It is doubtful whether more than one specific article can be included in the same registration. The statute requires the particular description of goods, and if that be not given, a valid foundation will not have been laid for an action at law or suit in equity, and a court would probably reject the letters of registration, just as it would a patent with a vague, indefinite specification of an invention or discovery. A man may affix the same symbol to many different articles, but in all cases he must be prepared to show the actual application of the mark or symbol to the article on which a rival shall have used it. It is true that applicants sometimes prefer such sweeping, comprehensive descriptions. The risk is their own. In one case in court, the plaintiff, a corporation, conceded that it had never manufactured prints, but because it had placed its trademark on everything in the way of cotton goods, except prints, it insisted that it also had the right to place them there, and that if any other person, however honestly, placed the same mark upon prints, it would be an infringement. The idea of the corporation was that the class of cotton goods was broad enough to cover everything that might possibly be made out of cotton, however unlike their products. The judge who had the cause before him said, "I deny emphatically that the doctrine of trademarks is capable of indefinite expansion, that where a word of meaning, a geographical word, is used as a trademark, and first applied to one branch of manufacturing cotton goods, when there are subsequently invented several distinct branches to it, like Aaron's rod, it swallows up all the subsequent branches. The doctrine of trademarks must not be extended beyond its just limits, or, in a country like ours, filled as it is with enterprise, capital, skill, inventive genius, and with men possessed with progressive ideas, it will, in the end, be productive of greater injury than good." Section 311. It seems scarcely necessary to remark that this statute is applicable to merchandise alone, something to be sold, and not to be given away. The plaintiff claiming protection must prove that he has an exclusive right to use a particular mark or symbol in connection with some manufacture or vendible commodity, and, secondly, that this mark or symbol has been adopted or is used by the defendant, so as to prejudice the plaintiff's custom, and injure him in his trade or business. There is not any exclusive ownership of the symbols which constitute a trademark apart from the use or application of them to a vendible commodity. This is the settled doctrine of all the courts. Any other view of the matter would be wildly absurd. A symbol does not become a trademark until actually stamped upon or otherwise affixed to goods to be sold. It would not therefore be correct for one to say that his trademark is stamped upon his business cards, or other mere advertisements, for the impression of the symbol would be nothing more than a facsimile or copy of his trademark. The public do not purchase signs, or circulars, or cards of business, but they buy the article of merchandise bearing upon it a certain known mark of genuineness. Yet, for all this, the dictates of common sense are set at defiance by muddle-headed solicitors, who will not think, how can a thing be a trademark if not used in trade? How can one's property be protected if he have no property? Section 312, lest the proposition enunciated above should not be considered authoritatively given, let us consult the bench. Ludlow, J., in 1860, said as follows: "It may be remarked in general, that while an imitation or facsimile, or a mere colorable artifice, will bring the offending party clearly within the rule, no decision has ever yet declared the right of a manufacturer to be absolute in a name as a name merely. It is only when that name is printed in a particular manner upon a particular label, and thus becomes identified with a particular style of goods, or when a name is used by a defendant in connection with his place of business, and not his manufactured goods, under such circumstances as to deceive the public and rob another of his individuality, and thus destroy his fame and injure his profits. That it becomes a trademark, or in the nature of a trademark, and as such entitles its possessor or proprietor to the protection of courts of justice. These remarks are so consonant with the rules of common sense, that it would be unpardonable in a writer to produce additional authorities, were it not for the fact that the office has been pestered with the declamatory nonsense of persons who contended to the contrary." To continue, Vice-Chancellor Wood, of England, in 1865, said, "The law on this point, as laid down in the cases before Lord Westbury, I understand to be as follows, and I do not think that anyone would be disposed to dissent from it. This court has taken on itself to protect a man in the use of a trademark as applied to a particular description of article. He has no property in that mark per se, any more than a person has in any fanciful denomination which he may assume for his own particular use without reference to his trade. If he does not carry on a trade in iron, but carries on a trade in linen, and stamps a line on his linen, another person may stamp a lion on iron. But when he has appropriated a mark to a particular species of goods, and when he has caused his goods to circulate with that mark, when that mark has become the known indicium of their being his, the court has said that nobody shall defraud him by using that mark, and passing off the goods of another's manufacture as being the goods of the owner of the mark." And the Lord Chancellor in the same year said, "It is correct to say that there is no exclusive ownership of the symbols which constitute a trademark apart from the use or application of them, but the word trademark is the designation of marks or symbols when applied to a vendible commodity, and the exclusive right to make such use or application is rightly called property. This rule is as rigid and unalterable as the laws of the Medes and the Persians." Section 313. Third, a description of the trademark itself, with facsimiles thereof, and the mode in which it has been or is intended to be applied and used. The description should be so lucid and comprehensive that the language of the specification shall require no extraneous aid in its interpretation, to identify the appropriate device or symbol. The words, as shown in the drawing and facsimiles hereto annexed, or equivalent forms of expression, will not suffice, as in point of fact the facsimile is annexed only to the certificate of registry, and does not appear in the specification, of which several hundred copies are printed for possible use. By a recent regulation, the representation of the trademark may be printed as a portion of the specification. In that case, it is not annexed, but incorporated. An allegation that the mark consists of a schooner yacht under full sail, in connection with the words, Middlesex Yacht Cloth, as is more fully shown in the facsimile hereto annexed, would be unobjectionable. Sometimes the representation filed consists of fanciful groupings of figures, or of ships and railway trains, and bridges, and a number of words, while the essential mark lies in a single word. The verbal description is, therefore, the only true guide. Section 314. 10 facsimiles must be filed, when the representation consists of an engraving, lithograph, letterpress, &c. But when it consists of an original drawing, made in accordance with the office rules, and which may be photolithographed, that will be sufficient without facsimiles. Section 315. Mode of application or use of mark. This may be set forth thus: by marking each article with blue ink by means of a stencil plate, by printing the mark upon tags to be fixed to the cloth, by branding the top of each box containing the goods with a hot iron, by painting or stenciling the mark upon each article, or in any other language which will clearly show the mode of affixing the same. Sometimes the articles intended to be protected are too minute to bear the mark, as needles, when the box will perform that office, or pins, when the paper in which they are fastened will serve the purpose, and so of a myriad of those articles to which the emblem cannot be affixed, except by means of envelopes, wrappers, boxes, and other enclosures. Section 316. Fourth, the length of time, if any, during which the trademark has been used. Preciseness upon this point may become an important item in a contest for the establishment of priority of adoption. A neglect to accurately fix the time may operate as an estoppel in the event of conflicting claims, and limit the date of adoption to that of application for registry, and at all times it might justly be regarded as a suspicious circumstance, as, for example, when it is stated that the mark has been used for a long time, or for a number of years. If the applicant state that he has adopted, and intends to use, &c., he would be precluded upon trial from going behind the record, and giving evidence of long user. If he state that he has used the mark for 10 years, and the proof be that he has used it but 5, would that not be regarded as evinctive of bad faith? Here is one thing that should be carefully looked into by the applicant before registry, and by his antagonist at the trial. It frequently happens that the application, as filed, alleges that the mark therein described has been used for a certain time, or number of years, and then upon an afterthought, perhaps on account of rejection, the description is amended so as to materially change the symbol itself, and not upon oath. The seventh subdivision of the section we are now considering calls for a declaration under oath that the party has the right to the use of the trademark, and that the description is true, and c. What trademark? Clearly that which was used for such a time, and not that which appears in the amendment. An irregularity in this respect may be fatal to the plaintiff. Therefore, when an application is amended so as to alter the symbol in any essential feature, let the oath be renewed. It has been said upon very respectable authority that this part of the section as to oath is merely directory, and within the discretion of the Patent Office, and that consequently the issue of a certificate of registry would cure all defects. This is an error. When a patent has been issued, and the letters contain a recital that the inventor duly made oath, and c. that recital would be conclusive in case of not finding the required affidavit on file, for it would fairly raise the presumption that the affidavit had been misplaced. But if the affidavit be found on file, and its statements be insufficient or repugnant, that would be conclusive evidence of the fact that the office had no jurisdiction. So, in a trademark case, may the response be, coram non judici. The office does not arrogate to itself the doctrine of infallibility. Section 317. Again, it is a sound doctrine that a symbol may be a lawful trademark, from the facts of long user and established reputation, which could not be so considered if but recently adopted. Judicial decisions may be invoked to prove that the thing has been involved in forensic strife where its legal sufficiency was brought into question, and affirmed. Notoriety from long-continued user may give a currency and value that could not be predicated of a brand new mark, just as a neologism, which in its inception was an unknown foundling, or cant, or slang, has been adopted into the family of legitimate words, and holds up its head with the stateliest words in the standard dictionaries. The rank is but the guinea's stamp, but the guinea gold would lack currency without the stamp. A hieroglyph, or a combination of letters, may pass almost without challenge on account of venerable age and universal recognition, which, were it to come unheralded and without indication of antiquity, would be subject to rigid scrutiny and criticism. A common word might be rejected unless it had come to denote merchandise as originating with some particular person. The association may say that a title by prescription will have been acquired. Section 318. Fifth, the payment of a fee of $25. In the same manner and for the same purpose as the fee required for patents. The payment of this fee is an essential prerequisite to placing upon file for examination. When once paid, as in case of duty paid upon an application for a patent, or on the filing of a caveat, it is not a pledge or deposit of the money, but an absolute and unconditional payment into the Treasury, and it cannot be reclaimed unless it should have been paid by mistake. As when one intending to apply for a copyright erroneously applied for the registry of a trademark, or in any other case where the Patent Office had no jurisdiction of the subject matter. Section 319. Sixth, the compliance with such regulations as may be prescribed by the Commissioner of Patents. The regulations may be found in the Rules of Practice of the Patent Office, established by the Commissioner, subject to the approval of the Secretary of the Interior, and perhaps in orders made by the Commissioner alone under authority of this subdivision. Whether the approval of the Secretary is required in trademark cases is not settled, and indeed has never been formally called in question. Regulations have all the force of statutory enactments, and, until repealed, are as binding upon the officers upon parties. Section 320. Seventh, the filing of a declaration, under the oath of the person, or of some member of the firm or officer of the corporation, to the effect that the party claiming protection for the trademark has a right to the use of the same, and that no other person, firm, or corporation has the right to such use, either in the identical form or having such near resemblance thereto as might be calculated to deceive, and that the description and facsimiles presented for record are true copies of the trademark sought to be protected. It is not sufficient to make oath that no other person, firm, or corporation has the right to use such mark, or one substantially the same, but the remainder of the section must be included, so as to make out a prima facie case beyond all peradventure. The term oath is used, but an affirmation is deemed to be equivalent thereto, and in accordance with the spirit and reason of the law. Statutes in pari materia are to be taken together. Section 30 of the same General Act, where it relates to patents, uses the words oath or affirmation. By a necessary implication, to prevent the failure of a right because of conscientious scruples, the word affirmation must be interpolated. The English laws concerning paupers, and the Bankrupt Acts, are construed together as if they were one statute, and as forming a united system, otherwise the system might, and probably would, be inharmonious and inconsistent. Section 321. The manner of administering the oath, or affirmation, must of course be left to national or local peculiarities and customs, as in the case of heathen idol worshippers. The oath may be made in the United States before any officer authorized to administer oaths for general purposes, as justices of the peace, notaries public, commissioners of deeds of cities, or of judicial courts, and clerks and judges of the same, or, in a foreign country, before any minister, charge d'affaires, consul, or commercial agent holding a commission under the government of the United States, or before a notary public of the foreign country in which the applicant may be. The signature of a notary public must in all cases be attested by his proper official seal. Sometimes the official seal is dispensed with by state laws, but under federal laws it cannot be. Of course the oath prescribed in this act cannot be taken by anyone who has been convicted of perjury, or who for any other reason is not a competent witness in a court of justice in the state or territory where the party proposes to take it, and if, upon interference or other trial it appeared that a person legally incompetent had sworn to the declaration, the case would stand exactly as if no oath had been made. Lapse of time could not cure a defect so radical. Section 322. The oath must comply with the statute. In a patent case, it was held that an oath that an original patent is not fully valid and available to the patentee, is not such an oath as is required by law, and it was an excess of authority on the part of the Commissioner to grant a reissued patent upon such an oath. Section 323. Jurat. There is no act that requires the jurat to an application to be dated. Section 324. Certificate of officer. In one case it was questioned whether a notary public had complied with the Act of Congress of September 16, 1850, which allows oaths to be taken before a notary public, and when certified under the hand and official seal of such notary, shall have the same force and effect as if taken or made before such justice or justices of the peace. He did not state in his certificate that he was a notary public, and that such certificate was given under his official seal, but signed the same, and affixed his seal. Held sufficient. Section 325. Where there is no oath on file, the fact that a blank form of oath not executed is found among the papers cannot overcome the direct recital of the letters patent that the oath was taken, or the presumption that the requirements of the law were complied with in issuing the patent. And suppose the oath had not been taken at all, would the patent be void on that account? Story J. In one case held otherwise. The taking of the oath, it seems, though to be done prior to the granting of the patent, is not a condition precedent, failing which the patent must fail. Notwithstanding the tenor of the foregoing decisions, no prudent applicant would neglect any of the formalities required, nor lay the flattering unction to his soul that he can eventually succeed if he do so. We have an opinion in the Crompton case, above cited, that even the requirement for the payment of fees is directory, and that the non-payment thereof would not invalidate a patent inadvertently granted. Obiter dictum. Section 326. Officer of the Corporation. The President, Vice President, Secretary, Superintendent, or the Treasurer. It has been decided by the Special Examiner that the oath of a mere director could not be received, he not being in strict language an officer. The Chief of the Office had never decided the question. Section 327. Calculated to deceive. However strong may be the asseveration of the applicant upon this point, the declaration will not be conclusive. Where the statement is obviously false, motives will be keenly scrutinized. The office will for itself determine when a proposed mark is calculated to deceive. Nor will motives be the sole test, for it is not essential to reprobation that the use shall have been with fraudulent intent. In Fettridge v. Wells, the Balm of Thousand Flowers case, J. said, without rejecting the evidence of my senses, I cannot doubt that the label or trademark which the defendants admit that they propose to use, from its general resemblance to that of the plaintiff and his firm, is well calculated to mislead the public, by inducing the belief that the articles to which it is affixed are in reality prepared or manufactured by the plaintiff's firm. Nor can I doubt that the label was framed with this design, since the imitation is so close, minute, and exact, as, in my opinion, to exclude the supposition of any other motive. It is true that the name of R. H. Rice, as proprietor, is printed on the label, but it is so printed as not to attract, but almost certainly to elude, observation. A variation must be regarded as immaterial which requires a close inspection to detect, and which can scarcely be said to diminish the effect of the facsimile which the simulated label in all other respects is found to exhibit. The question of general resemblance, with variations in nearly all the minutiae, was fully considered by the office in an application for registration of a proposed trademark for paint, rejected upon registered case number 1 of the Averil Chemical Paint Company. The verbal description of the Averil Company reads as follows, viz., in the foreground, on a rock, with the word chemistry upon it, is an eagle holding in his mouth a paint pot or canister, with a brush, and a ribbon or streamer, on which are the words, economical, beautiful, durable. Below the feet of the bird is represented water, upon which are a steamer and other vessels. In the background is a bridge or viaduct, with a train of railroad cars upon it. Further in the background are seen buildings and manufactories. The applicant's specification presented the same general effect. Omit the word chemistry, said the special examiner, add the figure and to the ribbon, and substitute a globe for the rough rock, and the written description of Bradley is the same as that of the Averil Company. At a casual glance, one design might easily be mistaken for the other, an indistinct impression of which may have been left upon the memory, for each contains all the essential features of the other. Both devices are circular in form, are intended to be applied in the same mode, in the same color, and to the same class of goods. It is not to be supposed that opportunities for critical examination would commonly offer, nor even be sought, for the resemblance of the infringing to the genuine mark would lull suspicion, so that not only the general public but even acute observers in the business of dealing in paints might easily be misled. If the affidavit filed in this case had been conclusive, the case could not have been rejected, for that affidavit states positively that no other person, firm, or corporation has the right to such use, either in the identical form, or having such near resemblance thereto as might be calculated to deceive. This is by no means an uncommon kind of case. The moral of it is, that the Patent Office will examine, weigh, scrutinize, and decide, in accordance with the rules of common sense. Section 328. The statute, by defining the conditions under which the power it confers shall be exercised, necessarily excludes it in all others, except, perhaps, the correction of clerical errors. When a statute defines the extent of power to one who acts ministerially, as the Commissioner does under this section, the courts cannot extend it, nor validate acts done without or beyond its authority. The Commissioner cannot pardon a false suggestion, or excuse on the ground of innocent ignorance. If, for example, an alien, either through ignorance or intention, falsely represent himself to be a citizen, in order to obtain a patent, the patent so obtained is inoperative and invalid to vest title. Where the taking of the oath is a condition precedent, the want of it may be pleaded in defense. Section 329. In another case it was held that the Commissioner has clearly no power to dispense with what the statute declares to be the necessary prerequisites to the grant, and if it appears from the records and papers of the office in evidence that the statutory requirements have not been complied with, it is within the power of a court, and its plain duty, to hold a patent to be void. It would be straining the doctrine of presumption in favor of the legality of the acts of a public officer to an unreasonable extent, to hold that a patent is legal and valid where the records and papers of the office show conclusively that essential statutory provisions have been disregarded.